What if I told you a perfectly planned estate could still end up in court, not because it was poorly written, but because something changed behind the scenes? They did everything right. They hired an attorney. They created a living trust. They funded it. They updated it over time. They believed their family would be protected, and yet, within months of the funeral, their children were in court. The very plan meant to prevent conflict became the reason for it. This is not rare. It happens more often than people realize, and it almost never happens because of one single mistake. Estate plans collapse when multiple warning signs are ignored. The first and most common trigger is doubt. Doubt about whether the estate plan truly reflects the person's wishes. This usually comes from two issues: undue influence and a lack of capacity. Undue influence is not always obvious. It does not require force. It can be subtle. A caregiver, a family member, or someone close begins to gain trust, control access, and slowly influence decisions. Over time, their wishes replace the original intent. At the same time, capacity becomes a concern. Illness, dementia, medication, or cognitive decline can affect decision-making. When changes are made during these periods, they raise serious questions. There are clear warning signs. Changes made during illness or hospitalization, a new person becoming deeply involved and suddenly benefiting, isolation from family, sudden changes that contradict years of expressed intentions, and most importantly, when the person themselves cannot explain their own decisions. The second major trigger is trustee misconduct. Even if the estate plan is valid, the person managing it can cause everything to fall apart. Trustees have a legal duty to act in the best interest of all beneficiaries, but sometimes they do not. They delay distributions. They avoid communication. They use trust funds for personal benefit. They favor certain beneficiaries over others, and often it starts small. A delay here, a vague explanation there. But over time, the pattern becomes clear. The trust is not being managed properly. Warning signs include lack of transparency, delayed distributions, unexplained expenses, and a lifestyle that does not match the trustee's known income. The third trigger comes from blended families. Second marriages create complex dynamics. A parent wants to provide for a new spouse while also protecting children from a previous marriage. On paper, this balance may look fair. In reality, it often creates conflict. Children may feel replaced. Spouses may feel entitled. And when one person controls the assets, the other side fears losing everything. Warning signs include major changes after remarriage, reduced inheritance for children, increasing control by the new spouse, and growing distance between the parent and their children. The fourth trigger is unequal treatment without explanation. Parents have the right to divide their estate however they choose. But when the distribution is unequal and there is no clear explanation, it creates suspicion. Children begin to ask why. They question whether the decision was influenced or manipulated. They look for answers, and often they turn to the courts, especially when the favored individual had the most access during the parent's decline. The fifth trigger is something many families completely overlook: beneficiary designations. These designations override the trust. That means assets can be redirected outside the estate plan without changing the trust itself. If one person is named on accounts, they receive those assets, regardless of what the trust says. Warning signs include changes made during vulnerable periods, inconsistencies with the trust, and multiple accounts being redirected to the same individual. The sixth trigger is secrecy. When families are kept in the dark, suspicion grows. Lack of communication creates uncertainty, and uncertainty leads to conflict. This can include a parent becoming secretive, one person controlling all communication, restricted access, or a trustee refusing to provide information. Secrecy does not always mean wrongdoing, but it often leads to litigation. And the final trigger is last-minute changes. Changes made close to death, especially during illness or heavy medication, are highly vulnerable to challenge. The timing alone raises questions. Why now? What changed? Who was involved? When these changes benefit the person with the most access, the risk of litigation increases significantly. Here is what most families do not realize. It is not one trigger that causes the problem. It is when multiple triggers come together. A vulnerable individual, a new influencer, changes made during decline, lack of transparency, unequal outcomes. When these combine, conflict becomes almost inevitable, but this can be prevented. Clear communication is one of the most powerful tools. Families should understand intentions, even if they do not agree with them. If distributions are unequal, explain why. A simple explanation can prevent years of conflict. Ensure beneficiary designations match the estate plan. Review them regularly. Choose the right trustee, not just someone trustworthy, but someone capable of managing both finances and family dynamics. And most importantly, document decisions, especially later in life. If you are already seeing warning signs, do not ignore them. Preserve records, ask questions, understand your position, and act quickly, because time matters. Evidence disappears, assets move, and legal deadlines can limit your options. Here's the reality. Estate plans do not fail because of paperwork. They fail because of people, timing, and lack of oversight. But failure is not the end of the story. When something feels wrong, it usually is worth investigating, because estate plans are meant to protect families, not divide them. And if they begin to collapse, the sooner you act, the more you can protect what was intended.